changes are there. So we know that since last 3, 4, 5 months, there have been so many changes which has happened in our life also, in our practice also, and also throughout all over the world. There are so many changes which has happened, and some new things have come up, some opportunities have come up, and that also we have something which has come up, that is a Consumer Protection Act, which was 2019, which was tabled in 2019, and then it was passed. It is applicable now since 20th July 2020. So that act is now applicable now, and that is actually bothering us. And ISSP has been trying to get this medical legal coverage for all our members, and also the indemnity insurance for under the heading of the pain medicine. This we have been trying, myself, Dr. Kailash, our president, we have been trying since last 1 year. And this delay was happening because of this act, because this was about to come. It was lingering since last 1 year. But now, since it has come into force, so we consulted one of the very senior lawyer, advocate Arun Mishra. So we are very glad that, sir, you are here from your very busy schedule, because we know that these days, I know that you are doing a lot of webinars, lot of training sessions for the government officials also. Few of them I have attended also for with regard to telemedicine, because a lot of changes have happened and telemedicine is going to come in a big way. And with that also, there is a lot of medical legal hassles are also going to come. And you are one of the pioneers in the framing the telemedicine guidelines. So we are very thankful to you, sir, that you are here and you are giving your valuable time to all the members of ISSP. So Dr. Mishra, he himself is a doctor, and he is a lawyer also, medical legal services. That is his main domain. He's a advocate. He's a lawyer in the High Court and the Supreme Court of India. And his main interest is, since he's a doctor, his main interest is in the medical legal domain. So I welcome you, sir, for this webinar. So all of our members are uh, basically eager to listen to you. Uh, and the punchline of our webinar, as you know, that to prepare and protect yourself. So that is the punchline of our webinar. So I'm sure you are going to cover that in a detail. To all the members, I would request whatever questions you have, you have a chat box open. You can just type your question over there. Once Dr. Mishra brief us about the changes, what has happened in the Consumer Protection Act and also in the telemedicine, after that we'll start taking the questions. So for 30 minutes, he's going to speak about all the changes, and then we'll take the questions for 1 hour. Okay. Before we start, I would request our President, Dr. Kailash Kothari, to please address our gathering. Dr. Kailash.
Yeah, thank you, Pankaj. And I think this is one of the most important project what we were taking. And now we had a clear understanding with Dr. Mishra and his company that how we can go ahead and along with indemnity, how we can protect ourselves from legal hassles, medical and legal, both are very important. So I request everyone to listen very carefully, take it very seriously, and also raise all your doubts and questions, because this is the platform where we can ask and clarify all our doubts, so that we are safe in the future. So I give mic to Dr. Mishra, Dr. Advocate Mishra. So he's doctor also. That's the best part. And few of our members, they are already his client, and they are very happy with his services. So it was a very positive thing for us.
Thank you, Dr. Kailash, and a very special thanks to Dr. Pankaj and Dr. Kailash and the whole team here waiting for such an interactive session. I really thank every people here to trust me on the topic, but I'll definitely prove that your time could be invested in this particular domain is going to be very fruitful. And as rightly said by Pankaj, the tagline itself talks about the protection. I strongly believe, very, very strongly believe, that ignorance is the cause of suffering. It's not I am saying, it is a Gautam Buddha who said, and very clearly he guided to the world, if you really want to cease the suffering, replace ignorance with the knowledge. So it is only a knowledge which is going to save you. And today in this session, we are going to share the knowledge only. Probably your ignorance may go off, and hereafter you can be capable of protecting your own self. This is going to be the webinar with the knowledge, and rightly said by Pankaj, I was really stuck today. I was really very difficult situation to take this session, because morning I got a call from one of the physician in Mumbai itself, where he admitted a 18-year-old girl. See, I'm just starting because it is a medical law case only. It is a 18-year-old girl got admitted in this hospital, and initially with unconscious stage, nothing was very clear. But next day, some anonymous call. Earlier, the patient has given a history that patient fallen from the bed and got admitted here with unconscious state. But next day morning, he got a call from some anonymous people that there is some fishy thing happened, and this girl was taken to some Baba Bua for the treatment of some psychiatric thing, where some inhuman treatment probably have been given, and it is just to intimate you. Knowing that, he immediately done the MLC. CT scan was showing hemorrhage of a brain. When he probed the patient and the relative, he came to know that this lady, the girl, was taken to some Baba Bua for the further treatment by the family. It is a South Indian family, Tamil family, and then Baba has hit it on a head or banged a head on a wall and done all sort of a jadoo tona, whatever was there, and patient expired morning. And the whole community was pressurizing this doctor for giving a death certificate, because probably the community was knowing. And not only that, not about the death certificate per se, but it was a allegation put on a doctor that patient died because of your negligence. And now doctor in a catchy situation, if I give a death certificate, then what could be my role and my protection? And if I don't give, these people are going to trouble me. I was engaged there, Pankaj, a whole this done, and this session is also I am taking from some other place. That the reason I was struggling in arrangement with some other's laptop, not in my proper place where I used to take. So I apologize if at all any interruption, because I am on a way where I am taking the session with you all people, since it's already committed session for the people. So now in this case, nothing I have done. I just told them it is mandate to go for the postmortem, because postmortem is going to reveal the actual cause of death. If turned out to be unnatural, then police need to investigate in view of murder also, or in view of 304 also. But if we don't follow the law and give a death certificate, I have earlier got 3 cases like this in my tenure of 18 years, where this anonymous calls lead to interruption by the police, and from the funeral site, the body sent to the postmortem. I said same thing can happen. The anonymous call police will receive, and body will be sent to the postmortem and turned out to be a murder or unnatural, and you are given a death certificate, then section 197 will come in a picture. The IPC says giving a false evidence for wiping of evidence is a heinous crime, another 7 years punishment. And then wiping of evidence of a crime 201, 202 is going to be troublesome with a negligence. So better to give a body to postmortem to the police, so that it can be ascertained what is the cause of death. So that was the reason why I was really struggling for this lecture, but thankful to all people allowed me for another 10 minutes to set up my things so that I can interact with you. Friends, why I shared this? Because these are the daily chores in our medical practice. You take a pain management clinic, or you take any of the domain, we are day in, day out are getting a trouble. And now trouble has increased to the extent where now we need to protect ourselves with something which needed in this country. Let me give you little idea about the 2 latest development which happened in our country. The first development which has happened during this scenario situation of COVID-19, the telemedicine law was accepted by the government. The draft was ready on this topic. There was a lots of discussion gone. The drafting has happened. And in 2018, when the case of Ratnagiri happened, where the gynecologist has given a treatment on a phone call in a post-delivery patient, which died due to their own disease and onset, the my gynecologist couple was arrested under 304 plain. Now, what is this 304 plain section in criminal liability? It says that causing a death without intention, with her knowledge. The word with her knowledge leaded to that. With the knowledge means it has been told to the court that this couple doctor was having a knowledge that they are giving a prescription on a phone or on WhatsApp without examining the patient, are having a knowledge that this particular medicine also can lead to death, which is very common in our pain management clinic also, because for any pain, you are going to get a, naturally pain is a one symptom which where the patient is absolutely most uncomfortable, and you may be getting lots of calls on a WhatsApp, on a phone, or could be another media for immediate relief of the pain in a follow-up also, and you are tend to and bound to give the treatment on a phone because they are their own patient. Earlier, it was not a law. Earlier, it was really a difficult scenario situation. While rejecting the anticipatory bail, Bombay High Court has observed that it is a very clear domain of a knowledge which this couple doctor was having, and they have not clinically examined the patient and not came to appropriate diagnosis or a provisional diagnosis and lead it to death. Bail got rejected. Later, they got bail in Supreme Court. But thereafter, lots of discussion happened in a medical practice where WhatsApp or could be a phone call prescription was tend to be a unlawful. But these were the struggle for the professional. Draft was ready with MCI, the Board of Governors in separation of MCI. Everything was ready, and COVID-19 scenario situation brought the scenario where social distancing become a norm, and the congregation of OPD or a crowd was needed to be avoided. So on 12th May 2020, government has adopted a draft of telemedicine, and now telemedicine is a law in our country at the base. So today, all my pain people can expand their horizon to all India now. Earlier, for new practitioner to stabilize their practice used to take a years. But for all new practitioner, old practitioner, because see earlier for 2 lakh crowd, there could be a 10 surgeon. But now every doctor has got 130 crore plus people to cater. So you can really promote yourself. Now you are under the telemedicine guidelines have been given a permission to treat anywhere in a country. So now state council will not come in a picture, because law itself says if you are registered with any state medical council, any state, it could be Gujarat, Maharashtra or any, you are allowed to practice across the country. So now you can cater a patient on teleconsultation. On teleconsultation means video, audio, WhatsApp, email, new patient also, follow-up patient also across the country. So when you got 130 crore plus patient to cater, you know you can settle your practice in very shortest time also. So this has made a great change in our medical practice, because it is a 360-degree change what I always can vision. And not only I say that it is going to be a new domain of a medical tourism, where once you develop the trust between the patient by giving a OPD treatment, tomorrow the same patient or their family member or a society member can be called to your center for any major issues. So this is going to be a game changer in a medical practice. But telemedicine guidelines, as yes, been given a clear go way from the government on 12th May by notification. Not only that, since it become a law, the IRDA, that is Regulatory Authority of Insurance, have written to all insurer to compensate or reimburse the OPD cost of a patient. So even medical claim policy, which was having a OPD provider, OPD services, are going to be reimbursed. So now it become a law. So win-win situation, patient is going to get a reimbursement of medical claim, doctor is legally allowed. And third domain of indemnity policy, I have seen many of the people were saying that new technology is not going to be taken care, and still the olden policy does not cover new technology. But we have already spoken to the various insurance authority, and insurance authorities also agreed to cover telemedicine liability of my professional. So all the three places legality is with you. Now you got all the opportunity, you utilize this particular domain to increase your horizon. So telemedicine is definitely a new domain. Yes, liability is going to be there all India. When you're treating a patient all India, liability is going to be all India. In liability session, it is very clearly defined under the telemedicine line, the criminal medical negligence, the civil medical negligence, that is in consumer code or civil code, or medical council negligence is going to be governed exactly as it is governed in person. Only thing that all India, you need to have an advocate, all India, you need to defend yourself, because if you are treating a Tamil Nadu patient sitting at Mumbai, or if you are treating a Mysore patient sitting at a Bangalore, then the patient can file in Tamil Nadu or a Mysore criminal case, civil case, consumer case, and medical council case. So now it is the domain of a patient to file. So only thing is that liability is going to be all India now. So telemedicine is absolutely clearer today, is a clear law. Make a use of it. Only thing that don't give yourself to any software agency by writing anything where you can be troubled by various liability. Second part, which we have really seen a change during COVID-19, is a law of violence against the medical professional, which was under Epidemic Act 1897 enacted by the government. And one of the beautiful law which has been got enacted, we all need to know the law so that we can protect our colleagues and self also for violence against the medical professional. Because this law, which has been enacted by latestly by central government during the COVID-19 situation, brings non-bailable offense against the violator. Non-bailable means they need to struggle to get a bail. Secondly, it brings another domain, that 7 years punishment, one of the deterrent punishment, so that violence can be avoided. Third, it is 7 lakhs compensation also under the law. Fourth, the process and procedure of whole trial must be completed in a year, means that lawmakers are very clear what they are intended to. So one of the beautiful law we have been experiencing now and witnessing the same. The third greatest changes what we are seeing is the consumerism and the law for the consumers. In that particular domain, the Consumer Protection Act 2019, the bill which was passed by the houses in last year and signed by the president on 9th August 2019, was already a law. And thereafter, on 20th July, it has been enforced in a country. 15th July, cabinet meeting has adopted the rules what they have framed, and 16th July notification came, and now it has been a law in a country. Because of this particular law, the old Consumer Protection Act 1986 has been repealed. Let me give a little insight on that particular law. Initially, in 2018, when the first draft was done, health services was brought in a definition as an inclusive part. Thereafter, IMA and various other association has made a UCRI representation to the government. Lots of objection was scheduled, and finally in 2019, the health services word was dropped from inclusion list. By dropping, all my medical practitioner, all my doctors thought that they have won the game, and now health sector are not in the domain of Consumer Protection Act. There was a big ambiguity and a confusion got created amongst the medical practitioner. Friend, medical practitioners are not a law people, so they read only a provision, not an act as a whole. But lawyers are always there to read an act as a whole to define anything, same as a judiciary. Now, friend, once the rules has been brought, again I have got thousands of questions from various sectors of India about the clarification on health sector. I feel that today also, if at all some of my delegates are still in confusion that health services is a part and parcel of Consumer Protection Act or not, I'll clear today with my experience and knowledge. There are a few points which we need to understand. What is the object of a lawmaker? The lawmaker's object is very clear, to provide a consumer complete rights. The first. Secondly, lawmaker has dropped the inclusion but not mentioned health sector in exclusion list. So when exclusion list, health sector is not brought, means it is deemed that it is going to be part and parcel of the act. Third important thing, when you read the act, you will find all services word. The all services means by default health services comes. When you read all other definition of the harm of a deficiency service or XYZ, everywhere directly or indirectly they have spoken about omission and commission in respect to the negligence. When you read the definition of establishment, they have very categorically mentioned the professionals. Professionals means doctor, engineer, chartered accountant, company secretaries, or it could be a advocate, but they are barred. So these are the professionals are included. And when you go and read the service definition, the definition of service, nothing has been changed in respect to 1986 Act. 1986 Act has got same definition which 2019 Act has got, which talks that all the services, including but not limited to insurance services, builder services, telecom services, etc., others. Now, here after telecom services, health services was the word which they have dropped. But after dropping, the definition has not changed, because definition says including but not limited to, means including these things, but whichever not been mentioned here is also included. So if health service is not there, it is included. So service definition, on the same definition in 1986 Act, the matter has gone to the Supreme Court in VP Satna's case, where Supreme Court has interpreted the law after referring the complete law and very clearly brought health sector under the purview of the consumer protection. So our health services are much included in 2019, and the lawmakers are very intelligent. When they have framed the law in 2020, if you read the mediation law under section 4, they have very clearly mentioned the matter which is having a grievous injury or death due to medical negligence, very clearly due to medical negligence, cannot be referred to mediation, means it must go to the district commission, state commission, national commission for deciding on merit. So friend, health sector is very much governed under the Consumer Protection Act. Let it clear. Now, what are the changes what we are observing today under this act? There are major changes what we have found in this act, which was not in 1986, is the act which have lawmaker has foreseen for next 10 years. So they have included total domain of e-commerce. So anything e-services or e-businesses has been covered under the domain of Consumer Protection Act 2019. So now telemedicine is going to be e-services. Not only that, lots of second opinion, online consultation are going to be e-services. So that has also been covered. They have covered advertisement in a large. Earlier, my doctor was troubled by the state medical council for giving an advertisement. So my doctors are covered by state councils if they do an advertisement. But if hospital does, if institute does, or some other legal entity does, they were not governed by the medical council. So that's the reason they were getting a benefit of the same. Now, because of the Consumer Protection Act, even if at all any hospital, maybe knee surgery, maybe hair transplant, maybe anything, if it is advertisement not in coherent with the things or the law, if it is a misleading, if it is exaggerating, if it is not on a scientific ground, then it can be challenged. So advertisement has been taken very seriously, including the endorsers, before, after, the photo, or the actor, actress promoting some product, are the endorsers. So they are also been brought in the purview of Consumer Protection Act, where penalty is 10 lakh to 50 lakhs rupees, and including the jail punishment. So now advertisement is very strictly taken in this Consumer Protection Act. Further on to that, the CPA, that is Consumer Protection Authority, as a new domain, and Consumer Protection Council as a new domain, had been brought under the chapter of the CPA Act, which is in a layman language is a watchdog. Watchdog means any person, any citizen can go to these people. Your patient can file a case against you if they have taken a treatment, but now any citizen can file a case against you even if they have not taken a treatment on the basis of any misleading advertisement and promotion you do. They also can go to the court and to this CCPA body, and CCPA body is going to inquire, has been all the power. So now every business is being governed by 130 crore population. So anyone can trouble us, not mandatorily needed to be a patient. So naturally what we can foresee, lots of extortion, lot of antisocial activists, lots of patrikar who are already troubling us are going to be more troubler to us if we are not protected properly, or we are not having a proper knowledge of the same. So advertisement has taken very seriously under this act. Further to that, they have spoken about unfair trade services and unfair contract. They are the two things services were already there, what we used to say restricted services, but unfair contract is a new definition inserted. Now, what is this unfair trade contract in respect to medical field? Whatever agreement we do with the patient, one paper which is very commonly known as a consent paper. Now, consent paper is also a contract. So anything in a consent paper or any of the paper which has been signed by the you and a patient, if it is not a balancing towards both the people, all the provision which is mentioned under is going to be an unfair contract which can be removed by state council or a consumer commission if people go there. I'll give example. Not for medical legal use, the word you put, or all the jurisdiction for any of the litigation is going to be daily only, or only arbitration is going to be the remedies. So words like this, where our high-headedness is seen, are not going to be accepted under the CPA Act 2019. So particular thing like a compelling for the deposits or overcharging in relation to competitive rates. Worst part, I'll tell you, worst part, two provision which I have read. One talks about the invoices. So telemedicine guidelines say that you need to release every invoices to the customer, any single payment you do. Now Consumer Protection Act makes a mandate, I'm using word mandate, compulsory on every service provider to give an invoice to the patient. Now invoice, we naturally give to the patient whatever amount we have charged them. Earlier also, in majority of cases, we may not give the invoices, but now it become a mandatory. And what law people says, invoices not as per your whims, invoices as per defined under the act. So the lawmaker has defined the invoice pattern in act itself. The invoice pattern means the 16-digit number on a bill, it should be continuous number cannot be tampered, the complete services must be mentioned in the bill, the complete total amount must be mentioned in the bill, and all description or amount where you have charge for various services like a disposable or nursing charges or instrument charge, XY, everything need to be described under the invoice, and it should not be tampered or it should not be scratched, or so everything has brought. And then what further law says, if you are not issuing an invoice, then it will come under deficiency in service. So even for the invoice, the consumer can go to the consumer court. One more thing which I read in that, what they say, disclosing the information of third person is going to be a deficiency in service. Now friend, in a medical practice, without disclosing to relative, how come you are going to give any block to the patient for relieving a pain, or how you are going to go do any surgical or other procedure in a patient? Naturally, you need to take a relative in a confidence. So friend, hereafter probably once law get interpreted, we need to take a consent for that also from the patient for disclosing the things to their relatives. So lots of changes are brought under CPA Act. Further to that, one of the greatest plus point what we could have able to see in this Consumer Protection Act is the insertion of a chapter of a mediation. So mediation chapter is a new chapter. And what do we understand by mediation is some third party intervenes where things can be settled out of the court. So earlier what we used to do out of court is going to be now legal. So if at all consumer files a case against us and both the parties are agreeing to settle the matter, then it can be immediate. Mediation cell is like a intervener who will come with a common terms condition for settlement, and they will pass the appropriate order. And greatest plus point, friend, once the order has been passed by the authority, the mediation authority, it cannot be challenged in any of the court. So that is going to be the final, which is being inbuilt, and various other things like CCPA has given so much power, like the medicine with a similar name we have seen already, or the potency of the medicine has been lost. Everything has been governed under the particular act. And two things which we all need to understand under the CPA Act is one, the jurisdiction, pecuniary jurisdiction. Now, what do you mean pecuniary jurisdiction? The amount of compensation sought. So here, under the new act, power of district commission is increased from 20 lakhs to 1 crore. So even in a micro interior, even in a district place, patient did not have to go to the state headquarters. So now file there. So power has been given to this. Further that anything above 1 crore up to 10 crores as given to state commission, which was earlier not there. So whole power is given to consumer for filing any amount of case. What new changes has brought, which is going to be interpreted in court of law, ki consideration paid, the word used under that every case is going to go to district commission, because in medical negligence case, even patient remains in hospital for 6 months, bill does not go above 1 crore. So what paid, not what asked. Earlier, what was asked was a jurisdiction. Like suppose 10 crore compensation I am demanding, so I need not have to go to state, I can go to district also. So now the amount, and after AMRI judgment was one of the judgment of a Supreme Court, where first time 11 crore compensation has been given to the consumer, 6 crore plus interest, has opened the domain, because Supreme Court has observed that human life cannot be compensated with any amount of money. Supreme Court has observed that even the housewife who provides the selfless services to the in-laws, husband, also teaches a child, and their career cannot be termed to be inferior than any of the service going women. So compensation must be counted accordingly. And then further what they said, for giving a compensation, mental agony, mental harassment, loss of consortium, legal fees, ancillary fees, everything should be concluded. And earlier it was because of judgment, but new act has brought these under the act itself, where they mentioned mental agony, they have mentioned mental torture, they have mentioned everything. So now advocate has got huge power to file any amount of case. Second difference what we have seen under this act is the filing of jurisdiction. One more provision added under this particular act compared to 1986, and that provision says consumer can file a complaint where he resides or work for gain with all of the rights. So where he resides or work for gain, the word itself says that the consumer can file a case anywhere in the country. Because in metro cities, we get a patient of Uttar Pradesh also, we get a patient of South also, we get a patient of Orissa also. They are working people there, but they are basically from their state, so they can file a case there also to trouble my professional. And unfair trade practice has already been defined. Very recent case of a consent, which we all people know. 2008, the Kashmira Kohli case has settled the law of consent. In our country, we used to, and today also we are using a pre-printed form as a consent. In 2020, 6th July, 2 judges bench of National Commission has clearly given a order, dictated order, which says that pre-printed form of a consent is unfair trade practice, and high headness of the hospital and arbitrators in the hospital one-sided. So it is deceiving. And while deciding this case, in that particular matter, where on a merit there is no medical negligence found against the hospital and doctor, but court said there is no merit in this particular case, hence application is dismissed. But to finalize and settle the pre-printed consent form, we are giving this order that hereafter pre-printed form having some blank space, doctor's name, procedure, XYZ, is going to be treated as unfair trade practice, and hence 10 lakh compensation to the hospital to be paid to legal aid. That is going to be precedent. So now pre-printed form. So lawmaker has put the word, the advocate are there to interpret every word, and we need to be really safeguarding ourselves. So lots of, it's not that balance has not been given. I'll tell you one great plus point in Consumer Protection Act, that frivolous cases, even the court wanted to block. Like I'll share one case where in upper respiratory tract infection, where this customer has filed 1.5 crore case in National Commission because he went to this particular doctor for URTI, upper respiratory infection, running nose, watery eye, and earache, body ache. And in that particular domain and scenario, the doctor has treated for URTI. Patient blessed the doctor after 5 days, and after 7th day, patient died at home. The died fallen at home, taken to medical college, had been treated there. Clear finding done by the doctor that she has got MI, acute MI, myocardial infarction, and treatment accordingly given. After death, postmortem was out. PM report again confirmed the cause of death is MI, acute MI, and this guy going to Google and trying to find out the connection between URTI and acute MI. Connection mean, and he could able to find one single point, earache was a symptom under URTI, and taking that earache to the acute MI, he filed 1.5 crore case against the couple in a National Commission, where he presented to the court that earache mimics jaw pain. Jaw pain is a sign of cardiac element, and doctors not done the workup. Friend, I argued that matter thereafter. It was a real nightmare to my practice now. But even you can understand URTI and MI is connected by, say, head to toe, we are connected. In medical science, everything, it is a complex science. So here, I argued the matter. I won the case, but the first time 10,000 penalty was given to the patient because the law says maximum amount was 10,000 for filing a frivolous case. Now in CPA Act 2019, the 10,000 is increased to 50,000. So even if at all frivolous case has been filed by the patient, yes, it is actionable if court feel that, because they also want to restrict such a thing. So CPA Act is already in a force. Now every case is going to be filed under CPA Act. Lots of changes and brought one more changes, which is worrying to a practitioner like me also. In a medical law, I'll tell you, and that was a hidden section which people don't read it. But now the new law says that case must be admitted within 21 days. If not, then it is deemed that it is admitted. Why I am sharing this? Because I'll tell you, being a practicing lawyer, I know what happened in the court of law. After lodging the case, it takes a long time to come on a board. But yes, doctor used to get a benefit because during admission, they were giving an opportunity to object the case at that first stage. And if they successfully do that, then matter does not go on a merit. That opportunity was with us. Now, because this is the new insertion, 21 days, if at all hearing is not done, which is, I know because of the load and because of the changes which is done in law of 4-member judges and other thing, and a lot of shortages are going to happen, no case is going to be heard. If it is heard, we are lucky enough. But if it not been heard in 21 days, then it is deemed admitted. And the same thing, what new changes has brought under Consumer Protection Act, earlier, if patient after filing never used to come to the court has been given a power to dismiss the application. Where being a respondent, if I give a letter, the client is not interested, the complainant not interested, we get a benefit. But new law says now even if at all complainant has filed the case, but never ever turn to the court, it is a duty of a court to decide the case on a merit, on an allegation in front of them. So lots of changes has brought, which is going to be consumer friendly. Friend, only thing I can advise to all my delegates here before I conclude my one-sided speech, then I'll take a question answer. The only defense left with us to protect us is to upgrade our knowledge. What the association has rightly done, I thank to President Secretary Pankaj, Kailash and the whole committee of taking a pain for their member to part the knowledge so that they can be protected. Ignorance can be replaced and you can really protect yourself. The first and important defense is upgrading your knowledge in a medical law so that people cannot cheat you, people cannot fool you. Second defense, which you need to really think on, is having a good professional indemnity policy. I am sure that every doctor has got, but my request and humble request, please go and read your policy, because the terms and condition mentioned policy always exclude the thing. Now world has changed. We are reached to new technology. We are reached to second opinion. We are reached to online consultation. We are reached to pain control management, what you all people are doing. all the technology has grown very recently, including the telemedicine, including the cosmetic domain, and you need to see that these are included under your indemnity policy. If it is included, you are absolutely safe. The customize the policy. Second, what you need to see in your policy, that it must be 1:1. What do you understand by 1:1? 1:1 means one case of 1 crore, or 10 case of 10 lakhs, or 20 case of 5 lakhs. Everything should be included. My doctor, for want of a premium, take 1:4. 1:4 means even if it is 1 crore policy, only 25 lakhs is covered. Means 4 case of 25 lakhs. Please don't do that. Have a 1:1 policy. Now you bang on out of court settlement because mediation has brought in. So out of court settlement, now customized policy are agreeing to give, because they are giving in accidental tribunal also. So why not in indemnity? In a rarest to rare case, or in indefensible cases, you see that the indemnity policy covers your legal fees. In matter that the fees is going to be reimbursed after the case get filed, but at least keep in mind that advocate fees to be covered, because in majority of case you win the case, but the loss of mental torture cannot be compensated, loss of reputation cannot be compensated, and the legal fees is again troublesome. So my friend, it should be a legal fees covered. So, and because you are going to need an advocate across the country means now consumer protection across the country, telemedicine across the country. So you need to have a legal fees. It must cover the legal fees. It must give a complete services. So now you need to choose an indemnity policy, which is a customized form, because time has come where we need to really think on that. And secondly, another part which my doctor does not understand, but is my experience says that everyone should have a medical legal expert with them. The medical legal service policy. Earlier it was not needed because cases were not there, but today lots of cases are happening. Future we are going to have lots of cases against us. My request that no doctor wanted to have a case against them. No doctor, because reputation plays a vital role player for their practice. Friend, to avoid all this, you have a medical legal expert on a fingertip. Opt for medical legal service policy, because what is not covered in indemnity is covered in this. I'll give a few examples to make you understand that. Pre-litigation. Suppose some litigation happened and you know he's going to be a potent litigant. You can immediately call to your medical legal expert, discuss with them. Like today's case which I shared. The guy has called me. I went there, settled everything. At least he has got good slip, peace of mind. Otherwise, he would have done a mistake by giving a death certificate, and tomorrow it turned out to be a murder case. In past, it has happened with 2 of my doctor. I argued they were behind the bar for 45 days till the time I got a bail, because the murder case was also implicated on them. Today, with my experience of 3 cases earlier, I could able to give a justice to this guy. Please don't do that. For smaller risk, don't take a big risk. Negligence can be handled, but murder cannot be. So friend, you need to have a pre-litigation support system. During litigation support system, during means suppose during the procedure something has happened, you have done the recitation, you have done every possible things, but still patient died. You have made all medical records. You know you are going to refer to the police for the postmortem. You know the ADR is going to be filed against you. You know that police is going to ask for the medical paper. So this is the time where before declaring death, take a help of medical legal expert. Audit your paper, send on WhatsApp, send on email, let third person also check it, and then submit to the authority. I'll give you one example. I always give that example because that was a touching example and known to my medical practitioner, where in one case the expert is opinioned that when growth was observed, clear indication of pulmonary edema. Why? Diuretic, Lasix given after 45 minutes. It's not that, my friend, we don't give. But while writing particular, we do fail. So during also you need a medical legal expert. Post. Suppose advocate has been appointed by insurance company and you appointed advocate and it is matter in court of law. Now my advocate are struggling with the terminology, asphyxia, hypoxia, neurotoxic, nephrotoxic. Now you are there to give them guidance. Now you are busy. They are free in evening, you are busy in evening. Both does not meet and the draft goes to the court of law and that draft get decided. So to cross-check your legal paper, to cross-check your document, you cross-check everything. If you got a medical legal services, during, post also they are there. Defamation. It is not covered in indemnity policy, but defamation is now a new norm in our medical practice. 80 crore population in this country is youngsters below 35 years age group, and they know internet. They are tend to defame you, and it send a notice to these people. What's harm? If they are violating a law, take a action. Don't keep mum, because your reputation is important. Recovery of the money, hardened money, 138 check get bounced, my doctor does not do anything. Payment is not given by the patient, ran away, half payment given, we don't do anything. Or send a notice to them. Have a medical legal service people with you, because they are there to help you even in a case of media trial, like media put their words in your mouth, need to discuss with someone what to speak, what not to speak, lots of benefit you get. So have a medical legal service which is going to protect everything which is not been indemnity policy. Have an indemnity policy which has got all technology covered, and have a very good legal education, repeatedly speak on some topic, discuss in association on some topic. I am there, always there for my people. I always see that litigation should reduce. I take all the lectures on every topic. Yesterday I have taken on consent, only lecture on a consent. I take a lecture on medical records. Have association, demand such a interactive session so that your knowledge get increased, ignorance get removed, and you can defend yourself. With this, friend Pankaj and Kailash, I am welcome for the question answer, because if I go on, I can go on for longer time. But I feel that people staying in various states, and every state has got their own law. People have got their own problems. Being in a pain management clinic, may have got lots of questions in your mind. So please welcome all the questions for the audience. If I am there with my experience of 18 years of handling a 15,000 plus cases, take advantage of that. Probably I am going to learn from your people. So over to you, Pankaj and Kailash, for any of the interactive or a question answer session, whichever they have in mind. I'll try to answer all with my best of
Thank you,
knowledge.
Dr. Mishra, and it was wonderful talk. I think it is so complicated that by listening only we are scared. But at the same time,
But don't scare. I have talked
but
about
that's
defense
what I'm
also.
saying. But
And
at the same time,
association is unity. If you form a unity, nothing is going to happen.
when we are listening, and we are also listening your knowledge, and we are feeling safe also. So that's good thing. Being scared is also good, and we know that somebody is after us is really very scary, and but somebody who is behind us to safeguard ourselves and to protect us is very important. And that is why we are all members. We want to tell that we have come up with a very good professional indemnity policy with a very good cost benefit to given to our association by Dr. Mishra, and we are thankful to him. And we hope that many members will take the advantage of that. We'll send all the details to you. But at the same time, we have many questions. So Pankaj, you can take the question.
So there is one question from Dr. Uttam. Is what is the regulations for the advertisements? Is there any guidelines or something is there somewhere? Some in the black and white we have something?
Yes. I'll tell you. The guidelines is already given in a 2002 regulation of ethics and ethics. If you read that, they have very clearly mentioned what all can be given to the people or displayed to. In that, change of the place, coming with any new technology like telemedicine, coming with some new practice, or if you are specialized in the practice, these are the thing which is allowed to you. Only thing that how we can use the words in advertisement, taking the advantage of these things which is in black and white. And if that has been followed, even we can pass some message to the people about the things what we want, but being remaining in any of the domain of these particular black and white given witches. You can ask me whenever you want to give advertisement or the wordings and drafting other things. I'll definitely help you in that.
Okay, Dr. Mishra. So if somebody is planning to do advertisement for change of place or new techniques or anything, what is suggested, if they are with you as a professional indemnity and medical legal assistance, your team will help them to
See, wherever it's possible, definitely.
yeah,
Only thing if you consult me, I'll definitely help you with that.
okay.
So similar question here says that uh, okay, not a similar question, but yes, definitely we already covered that thing. Does indemnity covers our pre-litigation consults also?
See, there is two things. Try to understand to all my people. Retroactive date is already given by the new company. Suppose you already got a policy with you, which is running from 2003, 2010, 2011, 8 years, 10 years, 9 years. The new insurance company takes the responsibility of all the cases of that by putting a retroactive date. So your new policy, if it is not broken policy, continuous policy, you need to tell your new insurance provider, whichever insurance provider you choose, you need to tell the insurance provider that these are the regular policy I've got. submit that policy. So retroactive date once been put on your policy, it means that any compensation of the older case, this company is ready to take. Now there is other policy which is known as claim made policy. I don't know if at all my insurer has been provided that and my doctor have taken that. So even if at all they have got a policy of 15, 16 and thereafter they have not gone with the same insurance company, and if that particular type case of that particular period comes, then that insurance company is responsible and liable to pay you compensation. So there's a two benefit which my doctor have got, and they should always look to that. So one is a retroactive date, and second is you need to know which policy you've got.
No, the particular question is basically that whatever legal fees and this thing is there, legal expenses in fighting the case, is also covered in the indemnity or not?
Yes, yes. That what law says, what the insurance people have said when we have negotiated with them, that if at all matter goes in court of law,
Yeah.
so we are going to include your legal fees and if at all compensation given by the court, and if it is under the coverage, we are going to give both. Suppose your coverage of 1 crore, your legal fees goes to 5 lakhs rupees, considering the fact, or then compensation going to 15 lakh rupees, then both together 20 lakhs compensation will be given to you. So insurance company takes only legal fees if it matter goes in court of law, otherwise no. So anything you do, if it matter goes to court of law, get registered, then whichever court it is, legal fees is covered.
Okay. So multiple questions on the consent form, sir, because that is the area now, because you are saying that consent form, the pre-printed form is not valid. So that's basically it's a bit setback for, I think, the medical professions, especially when the person is undergoing some interventional procedure or the surgery. In those cases, that is only, we used to think that that is our safeguard, but now you are saying that is not valid. So in that case, we have to take some consent, sir. We have to explain the patient, whatever we explain to the patient, what are the risks are involved, what are the alternatives of this treatment are involved. So how will you take that consent then, if it is not a printed form?
Pankaj, I'd add on to you because you are there as an activist, as a medical law, and you are taking support of all your people. So it is a good question, and I'm just trying to explain you with a law point. Probably you will understand far better way than the compared to all other delegates because you are already in a medical law. There is a one word which is known as ratio in a judgment. Ratio in a judgment means if any judgment is given and new case comes, if opponent cites the judgment and ratio is same, then this judgment is going to be applicable. Otherwise, it's not applicable. Now, if you read this particular judgment, I'm talking about judgment which is given on 6 July 2020, the ratio means the main part of the judgment says that blank space in a pre-printed form, which is going to apply for every doctor, every surgery, and every place is high-headedness. Now, why they said that? Reason was that we are still following a generalized consent in this country, even after Kashmira Kohli case has been settled. And Kashmira Kohli case has already spoken about the 4 main ingredient where you need to explain, give a adequate information. The word use adequate information before taking a consent. And while defining adequate information, what they said, the procedure, the process, and the benefit you need to explain, the complication of the procedure you need to explain, then alternative, if at all available, you need to explain, and then if at all they are refusing, the adverse things you need to explain by taking a refusal consent. And if this 4 ingredient, if you look to the judgment, talks about every procedure separately. Now anesthesia has got separate complication and surgery has got a separate complication. If I talk in your language of a pain management, if you are doing one procedure, a pain to treat a spine with some procedure, or pain to treat a soldier with some different procedure, both has got different complication. So when the complications are different, alternatives are different, the same standard format cannot be allowed. So now my advice to all my delegates, instead of making these blank spaces, you can make a separate, even it is printed, you can have a separate consent explaining every detail, every procedure wise, and then take a one paper handwritten consent mentioning that whatever is mentioned in annexure of this consent, annexure is that printed, has been explained in my language to me, are going to save your much time. Now it is not going to have blank space as in ratio. It is not going to have a anything can be added. It is not going to be journalized consent which is going to fit for every people, because every procedure is going to be different. So ratio can be avoided. This is what a advocate interpretation. I am being an advocate. I am interpreting to defend my doctor. So I am trying to make you understand. Okay, don't get panic with the judgments. We need to understand that is this judgment is going to be troublesome to me. Then how? If I follow the same pattern. But if I change my pattern, tomorrow can I defend in court of law myself? Answer is yes. So you need to invent the thing where you can safeguard yourself.
So, for the members, I just tell them about one of the consent form which we have covered, that is basically for the interventional pain procedures. So we already have this consent form. This is on print and it will be published in the next our journal. So what I'll do is, sir, I'll share this consent form to you. If you can
Please,
get
please.
that, and because this we have formed basically not for the as a general for the surgical procedure, we are specially designed for the interventional pain procedures. So I'm going to share that form with you.
Please, please.
Some changes, so we can find that form and we can circulate to all our members.
No issue, no issue. I am there.
So any other question?
In
Charges.
consent,
Yeah.
in consent, what is the role of video consent? Now we
Yes.
were hearing that we have to take video consent also and other things.
I'll tell you, video consent is a very, very good piece of evidence, a good piece of things, instrument, what we say, for the purpose of investigation. Yes, I definitely agree with you. It is going to save a lot. But because mass over, makeover, the face over, and the voice over is very possible, any video consent or any audio consent, unless being examined by the forensic people, are not being added as evidence as on today. But yes, law is developing very fast. Evidence Act 65B has been amended after the IT Act 2011 got amended, talking about electronic document. Sooner government is going to come with the CRPC amendment where the electronic document is going to be one of the part of evidence. They are going to amend the Evidence Act also. That time everything become possible. But today it is a very, very good piece of instrument which can save you a lot. So if you are following a video consenting, please go on and keep as a medical record. In telemedicine, again, the same is going to be a medical record. So keep as a medical record, and tomorrow if need arise, we can even send to the forensic and give a certification for the authenticity of the same voice and same face. Can save you a lot. But yes, one precaution you need to take, whenever you are taking a video consent, take a written consent of a videography from the patient, because privacy law and confidentiality law is always there. And to explain all my delegates, I give a very simple example. Whenever you go to mall, you will find a big board, you are under CCTV surveillance. So that means that you are intimated. So we need to take a permission before taking any videography of the patient. And that is going to be a good in future.
Okay.
But it must be with written. It is not going to suffice for you.
So there is another question is that by Dr. Bhavani Prasad, can we put the changes for teleconsultation on the advertisement?
Charges.
Maybe it's charges, yeah.
In advertisement, can we describe our charges?
Yes, the guidelines, if you read MCI guidelines and the etiquettes and ethics, they have very clearly said doctor must display their charges. There is no upper limit. But if you have decided some charge, you can display. So you can display the charges as per the MCI guidelines, Regulation Ethics and Ethics 2000, which very clearly tells the doctor must explain about their charges. Normally we don't do, but that is the law where we need to display or we need to inform the same.
So websites, Facebook pages, all these comes into advertisement, or it is?
Yes, any mode where you're somewhere something has been displayed for your comes an advertisement. It could be Facebook, social media, website, everything.
So basically, we have to be careful in choosing the language what we are putting there.
You need to be very careful with that.
So in social media, people are putting their new cases or whatever surgery or their.
Today they are lucky. Nothing. No one is there to object them.
So you mean it is illegal right now to even display the patient's pictures?
I don't say legal or illegal unless I see the piece of the things. What? See, now suppose I am giving example that surgery has been put it on YouTube. Now when with surgery, what are the coating done? See, only surgery is not going to be there. With surgery, definitely some court. And that court, what court, with what intention, with what testimonials, with what, everything is going to count for that.
As long as we don't have any case, we don't have to worry.
Yes.
Yeah, no. So we need
Then
to
also
know.
can be defended, Pankaj, don't worry. And I know you can defend well. I'm proud that you can take care of whole association now.
Not at all, sir. We just
And
need
you are there for that.
all the time. So there's another question from Dr. Vanita Ahuja. In clinical trials, there is a pre-printed form approved by the ethics committee of the hospital. So is this valid in the court of law?
See, again, let me repeat the same. Pre-printed form of the ratio of the same is not going to be allowed. Blank space, particular purpose and all. Now things have changed in our country. Unless this judgment is overruled by another judgment, this is going to be the precedent in this country, which we need to be very careful with that.
So Dr. Pradeep Jain is asking, he's in Gangaram Hospital. He's a very senior consultant of pain medicine. He is asking whether it is necessary to have the indemnity insurance and medical legal insurance in case of private hospital practice.
Yes. My answer is yes in any type of practice. If you go to hospital practice, if you are an individual, this policy is going to cover across the country wherever you go. But if it is a hospital must take a responsibility of their doctors. After Dhanaka's case, AMRI's case and various other judgment, the hospital has been given a maximum responsibility of compensation. In Dhanaka case, it is 100%. In AMRI case, it is 90% plus, because it has been presented to the court that in a cranial surgery, the consultant neurosurgeon gets 20,000 out of 5 lakhs charged by the hospital. So profit is much. So even if it is a practice of hospital is going to by default take care of the consultant, visiting consultant. But if individual name compensation comes, and the advocates are very smart, they make a doctor as a party and the hospital as a party. And if you being a doctor have to defend yourself, you need to protect yourself. So don't ever go with the myth that hospital has got indemnity, I am covered. My humble request to all my professional here, invest few thousand on you. Please invest few thousand on you, because you are earning a lakhs of rupees to protect yourself. You don't pay more than 1,000 rupees a month if you calculate. If not 1,000 rupees a month, I feel that professional of a pain management, for them 1,000 rupees a month is a big amount. So if it's not a big amount, please protect yourself.
What about these testimonials are uploaded online or on Google? There are comments and likes or the comments by the patient themselves. They write on our pages or on Google Map. So what is the legal
They
standing?
are going to be termed as an endorser, Kailash.
Okay.
Endorser means like Amitabh Bachchan is promoting some product or Sarah Kun is promoting. So endorsers are also brought under the purview of a Consumer Protection Act. For endorsers also penalties 10 lakh to 50 lakhs. And if at all some misleading, they can be suspended to give endorsement for a year and even the jail punishment. So lots of changes has brought under CPA Act, and the once it is actually color will be seen, lots of changes we are going to see in a country. Even I can say the product which has been termed as within 21 days you will get a fair color or you get a memory booster. These are the claim are also going to be challenged in the court of law.
Okay.
You will see the future of this country with this Consumer Protection Act 2019.
Okay.
So is that like we discussed about the private practitioners in government in a hospital, in a corporate hospital? Is this applicable to the government practitioners also?
Yes, because government, the Consumer Protection Act says either it should be 100% free for 100% patient, then you don't come under CPA Act. But even if one patient is charged for whatever purpose, 99% is not charged, you come under CPA. Even 10 rupees is charged in the form, you come under CPA. And in past, we have seen lots of, I represented many of the government hospital and doctor. So doctor and government hospital is also under the purview of Consumer Protection Act. So they need to have a policy with them.
So whether they are that particular department is charging or not charging, that doesn't matter.
Doesn't matter. It matter.
Okay. Okay. So
what about the people who already have their policies from other thing, and what policies we have come up? So can you just highlight the salient points?
Yes,
What is the
there is a rule
advantage?
of IRDA for all my delegates here. There's a rule of IRDA that if you got existing policy with you, suppose of 50 lakhs, and you take another policy of yours as a 50 lakhs, and if you intimated both the insurance provider that I have taken from them, I have taken from them, the in court of law, both combinedly will be calculated. So suppose 1 crore compensation goes, then both will come in a picture. Once one liability finished, other will come in a picture. That is the rules of IRDA in any of liability insurance. But you need to intimate, that is the rule. Secondly, you can opt for this policy. If at all you want to opt for this policy at present, you can have a same policy and get both the coverage. Once this finishes, you can continue with this policy and you can enjoy the benefit. Or thirdly, you can take a policy in a finishing date of this and continue with a new policy. So all the choices are left on the client, but every delegates need to be. But since Kailash, you have asked, my request that whatever you have negotiated with the doctor's rest for the policy is going for the limited period. So if at all delegates wanted to take a opt for the benefit, it is going to remain, but the rates are going to be for limited period. So my advice that if at all any of our delegates wanted, so let them go with the added on policy informing both the insurance companies so that double coverage they are going to get.
Right.
So there's another question from Dr. Kinshuki. The testimonials when we take from the patients and we upload them on the website or anywhere in the social media.
No, Pankaj, he discussed. They are called endorsers.
Endorser. They are the
We
endorsers.
discussed.
Even the patient is themselves, they are willing to give some endorsement of.
So they are also liable. Na? I said no, the patient is going to liable for 10 lakhs, 50 lakhs. They are giving a consent, so they are going to be endorser. You are endorsing your services. Na? Testimonial is endorsement.
Okay, so that is also considered as an advertisement. Right. Okay, so any other questions? Kiran is asking, Dr. Kiran Jaswal is asking, does everyone in private should go for the private indemnity as IMA PSS is there? What is PSS?
No, he answered that you can take an additional policy or you can.
IMA PSS?
IMA some policy must be there.
No, it is a personal security scheme.
Okay.
So it is as good as the indemnity policy only, but it does not cover the compensation because it is like association. Suppose you are association and you have formed association and taking XYZ amount, and you are claiming that we are going to provide you the legal service, we are going to provide indemnity. It is not an insurance company, it is an association where their personal security scheme has been brought. So every people have got their own ideas of bringing the things. So in that probably there could be one of the advantage what people have been offered. But in spite of having a PSS scheme, in spite of having anything, my humble request, because it is your life, it is you who are going to protect yourself. For me, it is at any time advisable for all my delegates to use their intellect of yours, because when problem comes, it is you only who are going to protect you. No one is going to come. It could be your years of experience, you may be understanding. If an issue comes, it is you who are going to defend. And the purpose for the same, you need to have a weapon. Without weapon, you're not going to win the war. So individual professional indemnity policy is a mandate. Take from any insurance provider, but it is mandate and it does not cost much, my friend. So don't ever try to save a money where you need to have a protective gear for you. Don't save a money in PPEs where life important. And when it is a personal protective is something PPE equipment, so it is your indemnity is going to like a PPE. So don't put your life in risk, invest on yourself.
No, definitely, that's correct. So what is the ideal, Dr. Sanjeev Sharma is asking, what is the ideal coverage should be in pain practice, considering the district consumer authority can see cases up to 1 crore. So what is your guideline suggestions to our members?
My suggestion, if you are a good practitioner, having a good number of patients, then 2 crore. If you got high class of patient, because they are the affordable patient. Like if you see the majority of cases in the country is against the corporate hospital. Reason behind that if people can pay 5 lakhs for the medical bill, they can pay a 1 lakh to the advocate. But you will find very less cases against the nursing homes. because people get exhausted with the money in medical, so they don't remain with a legal fees. So if you have a good type of patients, high quality of patient, go for 2 crore. If you got an average practice and you got a practice wherever, 1 crore minimum must be there. So 1 crore is ideal, but you can understand your own practice and the people you are catering. Accordingly, you can define your 2 crore or 3 crore.
The maximum is up to 5 crore we have, right?
You can go for 10 crore.
No.
But 5 crore is advisable.
Yeah.
5 crore is, because see, I'll tell you why. Because with my experience of 18 years, which I found, that code gives around 20 to 30%. That is not dictum. I'm just giving my experience. 20 to 30% amount of compensation sought. So if one has asked for 1 crore, it goes to 20 lakhs, 30 lakhs. So considering that fact, you need to have a coverage of 1 crore enough. But anything, if your practice is really roaring, then you can go up to 5 crores also.
So Dr. Kiran Jaiswal is again asking, pain physician separately covered in indemnity or not? So
Yes.
this is a very good question, because in the what Dr. Mishra has given us, he has given two options. He will explain that. He has given an option of anesthesiologist as a practitioner to take indemnity, and anesthesiologist surgeon to take as a policy. So
That is actually
can you just give
pain,
salient point on that?
that is actually pain physician surgeon and pain physician anesthesiologist. It is the
Yeah,
category like
yeah,
this.
yeah. Can just some
But
highlights.
I'll tell you again, see, it is depend upon the practice you do, which you disclose to insurance company. Now, if you are disclosing to insurance company about the criteria of practice, insurance company, see, always understand, it is a contract. You proposed, they accepted, and consideration is paid, that amount, premium. Then it become a contract. So your proposal goes to them. If they accept, means they have decided that this thing they are going to cover. Now, but let me, with my experience, add on to that. I always advise to go for higher premium. Reason behind that, tomorrow the insurance company does not get any point to exclude you from that, because highest premium is for anesthetic in any insurance provider and for the plastic surgeon. So if you are taking a package of anesthetic, so you are by default covered for everything. But today, if you take only for the pain physician and restricting yourself, and something, if at all exclusion clause insurance company gets, that your domain is going to be this, you used anesthesia, you used that, and they reject the claim, then we need to struggle to file a case against them. So my request that it is very, very clearly
No,
advised
Dr.
when I
Mishra,
discuss with.
Dr. Mishra, we have two categories: pain physician, anesthesiologist, and pain physician surgeon.
So pain physician surgeon can go with the pain physician surgeon policy. Pain physician anesthetic must go for pain physician anesthetic policy,
Which is higher.
which is higher. But pain surgeons are there now. They can easily go for pain, even if they are taking care of pain. See, pain, don't worry. Pain is a normal terminology. And in court of law, we know how to defend that word. So your policy is going to be protected to you. Don't worry.
So basically, Dr. Mishra is saying that all the pain procedures are covered in the pain physician anesthesiologist. All the procedures, whatever we discussed with Dr. Mishra, he has already said that all these procedures are covered under that category also. Apart from that, if you are also practicing anesthesiology, that is also covered in this insurance. Am I right, sir?
Right. Because surgeon is covered in anesthesia if you're taking anesthesia. But if at all you want to restrict yourself to surgery and you got a surgery only and you're doing that, you can restrict yourself to surgery, no harm. But advisable with my experience.
With our degree, I think better.
Yes.
Yeah, you go with the qualification, nothing like that.
Because we
Go with
already,
the qualification.
so it is better to go for the higher one.
Yeah.
Okay, so Manisha is asking that if we give some free consultations, like over the phone, will that be covered under Consumer Protection Act? Will that?
If you are charging one patient in your consultation, then your free is covered under that in consumer protection. If you are giving complete 100%, I said if you are charging one patient and 99% you are giving free, then also you are coming under the Consumer Protection Act. So that particular patient's free is not going to save you.
Everything is under medical.
So another question, sir, here is that this from my side. So like we get a patient from outside India. So suppose if some patient, international patient, he lands up in some problem, can he it means can he file a case against us in India or in his or own country?
No, Pankaj, it is going to be India only because we are governed by the Indian jurisdiction. So even if at all foreign people want to file a case, they can only file in India. They cannot file in their country.
But they can file.
Only in India. They can file in India. There is no question.
So there's another question about the cost of what we are discussing. So there is sociologist where they have a 1 crore of insurance at 9,000 rupees. So he's asking why the charges are 18,000 in our policy, what we are suggesting. So what is the difference? What are the
I'll
loopholes?
tell you, see, let me give you a very simple example. I was not aware about indemnity when I started medical legal service organized in 2005. And I used to protect my doctor without any indemnity till the time I came to realize because of some sources that indemnity policy comes under tariff in their insurance language and in a tariff policy. And then I could able to get some influence from the government and I could able to reach to GM where I have got a very clear idea about the power of this GM in any tariff policy. So standard insurance policy which is available in a country today, the same policy which you are talking about 9,001 crore, the same standard policy which is available in a country in the IRDAI rulings and under the insurance being a tariff policy is available with 1%, 2% and 3% of the coverage amount. 1% for the physician, 2% for the surgeon, 3% for the anesthetics of the covered amount. So if you are covered for 1 crore, anesthetic have to pay 30,000 plus GST, that is 36,000. Surgeon had to pay 20,000 with the GST, that is 20. You can go to Policy Bazaar, you can call to any of the agent. This is the standard rate in the country. Now knowing that it comes under a tariff, I could able to go to various GMs and explain them about the power they have got and negotiated with the thousands and thousands of a doctor's premium together. They are also there to have a business. They also know that compensation is not much. Only thing what they said, okay, up to 25% of a premium you are paying to us, we are absolutely happy to give a compensation without checking anything because that is our domain. 75% we need for all sort of a commission. And from years, I used to give them an indemnity policy, years, but not had any claim till date. And they are so confident. One, they have already got a 10 years of payment with them, not a single claim. Second, they are confident that the people who are going to defend them are going to win the case. That is the somewhere trust factor got defended. So they negotiated to the extent where I can go and I offered them a particular rate. I got a benefit of that and I have passed to all my professionals. So wherever association come, the same 24,000 which my surgeons are paying have been brought down to 12,000 also, in some cases 9,000 also. The same policy with a customized form. So basically indemnity become the domain of protection. So I have negotiated and brought this because my domain is only medical legal services. But if my doctors are getting benefit, why not have pass a benefit to them?
No, but the question is that in Indian Society of Anesthesiologists, their premium rate is almost half of what we are advocating.
So that's the reason the GM has got all the power to negotiate. And if you claim that I have got a group of 10,000 people together joining at one premium, I can bring to less than them, whatever offer to them. You come with a number. Ultimately, they are sitting there to business. If New India will not do, Oriental will do. If Oriental will not do, National will do. If ICSP will not do, Bajaj will do. So it is, everyone is there and they have been given a power. So that discount can be opted from the number of people they are going to join. In your case also, I have given a number of 150 doctors, if you've seen. But since I have got already good number of a doctor, I said even if at all 100 comes, no problem. Even if 50 comes, no problem, because somewhere compensation is already done. But if at all you want to have a good rates, you need to come with a number and a commitment. If you can also come with a good number and a commitment, we can negotiate to less than that also.
Okay, got it.
Another clarification, sir, here that what we're discussing about the complications and the negligence. Can you just throw little light on this thing, sir? Difference between the complications and the negligence, and in also negligence, we had different categories of negligence. So you can just throw some.
So, Pankaj, in court of law, there is nothing which get defined as a complication or negligence. It is the advocate who plays with the term. And wherever I need to defend my people, I always say that books has given something and it is known complication. And even the judgment of the court, if you read, judgment of court has very clearly said that doctor is not responsible for medical accident even in the form of death. Even in the form of death. If they have given a due care to the patient, means proper reciprocation. So that is going to.
It's 16 hours.
If you omitted to do, I'll give example of omission. I have shared multiple times the cases where in a lumbar puncture, the neurosurgeon has not given a local anesthesia, and matter has gone to the court, and court could not find on medical records anywhere LA word is mentioned. The court has given judgment against the doctor, saying that it is inhuman practice, omission of something, or commission of something. In one corporate case, I have seen in a severe septicemia case, in a road traffic accident, where my doctor was very sure that he's going to die. They have given a complete coverage of antibiotic. In that case, what they've given vancomycin injection 2 grams 3 times a day for 7 days. Patient died. But the relatives had filed a case only on that commission, that FDA has given a very clear guideline that maximum dose of vancomycin is 2 grams a day. But in this case, 6 grams a day was pushed, and he could able to bring some Google document that overdose of vancomycin causes nephrotoxicity and neurotoxicity, and 2 organ has already got in MOA, patient was in MOA. So commission of something which other will not do, omission of something which other will not do, is going to be defined as negligence. So complication and negligence is the domain of a due care is a negligence.
Yes.
Yeah. Anything else?
So another thing what we were discussing yesterday, that now whenever some person goes for into the court of the law, they say, file some case against you, the case first goes to the particular.
Pankaj, your voice is not clear to me probably. Yeah, please.
Yeah, can you hear me, sir?
Yeah.
So we were discussing about that whenever the person files a case, or if he sends some notice to you, the case first goes to the panel of the doctors, and in the panel of the doctors, a doctor from that particular specialty that has to be there. That is the new change which has come now.
No, it is already there in Jacob Matthew case in 2005, when in a criminal case court has given a judgment in 2005, very clearly said it must be referred to the committee, because not being an expert in medical science, advocate, police or judges, it must be sent to the expert. An expert preferably be government for impartiality, and secondly of same specialized field. They have word used in that, and that is from 15 years back. People were not following, but lots of judgment has started coming because of that, because forensic people used to give their opinion in a gynec case also, in surgical case also, in every case. So because of that, the cases was been argued in court of law. So now people have started realizing. So now committee has got a speciality of that particular field to decide and define about the case.
So basically, this committee can decide whether this complication, whatever happened, or this, whether it is a negligence or it is a complication, it's a known complication or not. That is what they are going to do.
Because if complication, everyone knows it is a complication. See, any medical accident is a complication only. See, whatever happens is a complication, but only it has been taken care or not is going to be defining things of the negligence. If all the care has been given, which one doctor need to give, then it has been under the domain of proper treatment, standard protocol of a treatment. So there's no negligence. So we being a doctor have been taught in academic year about every complication in every procedure. So complication is going to be there, not to worry about that. But care need to be defined under medical records.
So how much weightage do we have about from the opinion of the panel of the doctors? How much does it weight?
I'll tell you, in a criminal case, it is 100%, because in a criminal case, because of the judgment, criminal case does not get filed if it is openized by the people. In civil matter, it is just an opinion, it is just advice, it is not on a judges to accept it. And secondly, the opponent also can cross them on that ground. So in civil matter, because judgment nowhere talks about that, discretionary power is given to the commissions. So that the reason it is on them to follow it or not to follow it. But in criminal case, yes, it is 100%.
Okay. Okay, so as a group, yeah, so Dr. Sanjeev Sharma, we already have this all the claim procedure, including the anticipated discoveries. Everything is covered under this insurance policy, indemnity insurance policy. We already discussed that, and when you go through this the file, whatever we uploaded on the website, you can see all these details over there.
Dr. Mishra, one more question is that when any field is coming up with new procedures which are not done very commonly, and might be they are overlapping with other specialties, and which were not taught in our curriculum during MD and other things. So when at association level, we are Indian Association is teaching this technique to all their members. Is that is considered legal, or it's still out of the legal?
No, it is legal. You need to present yourself because now NMC bill is going to give a lot of power to you. Now MCI is in separation of board of governors, not taking wide decisions. But yes, but let me tell you, wherever it has not been mentioned, any new procedure which is not mentioned in a syllabus of any of the PG qualification, and it is a new invention, then MBBS can do it. I have argued a matter for hair transplant case, and I have got a landmark judgment in the country where the MCI also said that MBBS can do hair transplant. And my argument point was the same in one case where 2 years suspension of a registration was done by Telangana Medical Council in a case of hair transplant done by MBBS doctor, which led to necrotic fasciitis. I argued in Hyderabad High Court and got the stay on that. I appealed to MCI. My presentation was very simple, what you just now said. I talked about the Medical Degree Act and the requirement of Medical Degree Act, what you rightly said, new invention. I said Medical Degree Act talks about the syllabus, it talks about hand-on training, it talks about the Viva, practical exam and theory exam in particular thing. If these are the ingredients available for particular procedure in particular domain, then it has been said to be a domain covering that. My argument was that hair transplant was never been in the syllabus of a dermatologist or never been a subject of a plastic surgeon. And being a new invented field, when there was nothing, MCI either would have come with a hair transplant, a separate domain of a surgeon like pain management, or there could be somewhere defined. In absence of that, MBBS are allowed to do, because 2002 later the PG qualification has been given a clearer picture. So MBBS were allowed to do anything during those days. So my argument was that then MBBS can do it. And it has been accepted by MCI. MCI and their affidavit has said, yes, MBBS can do hair transplant. So in your case also, if there's a new invention or new surgical things or new things which has not been covered in any specialization, then for the purpose of the same MBBS, and you being a basic MBBS, it comes under your domain also. It is a question get decided in court of law. Right. So when we get opportunity, we get try to present to the court to get a proper interpretation of the law.
Okay. Any other question? Yeah.
No, that's it. So I think it was a good brainstorming session, sir.
Thank you, sir.
I'm sure that lot of queries have been solved here, and whenever we have any such queries or something related to the indemnity insurance, you can always write to issphu@gmail.com, and we can forward to Dr. Arun Mishra for his clarification on the indemnity insurance or any other subject matter related to the medical legal services. Is that okay, sir, with you, sir?
So I take opportunity to thank all the committee member of association, and a very special thanks to Dr. Kailash and Dr. Pankaj and their team member for making me in getting interacted to you all people. I feel that I have justified your 1.5 hour plus which you invested with me. I tried my
Okay.
level best that you should feel that you have been, you're really encashed your time. So very,
I,
very special thanks to all the delegates and the committee member, and I'm always there whenever you need me for any support. I'm readily available. If I don't pick a call, I do call back. But if you are in emergency, im matter you are a part of mine or not, you are always going to be part of mine. You can trouble me 10 times. Even if I'm good, I'll come out and I'll speak to you. But this I really thank, because I'll tell you reason behind that. I'll just take my one more minute. My reason of doing all this from last 2000 and last 15, 18 years was on single reason. Being a doctor, I have experienced. Being a doctor, I have experienced that we doctor with a fear of law, don't entertain emergency in majority of time. If I get MI patient or if I get road traffic accident patient, I know if I intervene, probably 50% chance that I can survive a patient or revive a patient. But 50%, there is a high chance that patient may lose a life. And with the fear of law, because of the trouble, even I and you and everyone refer a patient to higher tertiary care center, knowing that in a traffic, ambulance is going to get stuck. The golden hour period is going to get lost. And that happens where the guy loses the life. My friend, it is a very humble and very, very deep hearted request to you all people. Very, very deep hearted. You are the soldier of the society. You are the life giver. Friend, it is not one person who dies. It is a wife who dies financially. It is a parent who dies financially. It is a child who dies financially. It is a 5 people who dies with one guy. And if you can save one life, you can save a society at large. My journey of providing my knowledge and medical legal services, surrendering my medical registration for the cause of this, was with single aim and objective. If I can be instrument to create a confidence amongst my doctor by removing the fear of law, my doctor can save at least one life in their career, which probably would have lost. My journey is successful. With all this object I have started, and my humble request that please don't fear with the law. Law is going to be for you if you are there to serve a society and save a life. Thank you, friends.
Thank you so much, sir. Thank you very much.
thank you, and we hope that more and more of our members come forward and take this policy, so we can bring down the premium also, as you suggested.
That is understand. Huh. So that's I think a wonderful session, and I'm sure that people are now confident also. Initially, we thought that it's going to uh, people are going to have a fear of whatever is going to come in the Consumer Protection Act. But now, since your words, I think have given a lot of assurance to the people that you are there behind us to save all of us. Thank you so much, sir. Thank you very much, sir.
Thank you. Thank you, friends.
Okay,
Thank you.
we
Nice.
close the session here.
Yeah, please. Thank you.
Thank you.